let me introduce you to my legal beagle, Jazzy. She is part black lab and part beagle. I personally call her a legal. She is also my favorite child. Aren't you, Jazzy? So, legally, what do you think the difference is between my dog, Jazzy, and the couch that we are sitting on? Would you be surprised that the answer is there is no difference? Generally, it is true. There is no difference in the law. Therefore, in this podcast, I will be discussing the law as it is developed and applies to animals. However, before we can discuss this topic further, I must give my legal disclaimer. The information in this podcast is not intended to be legal advice and should not be used as legal advice. It is solely meant to be educational and informative. Nor is this podcast intended to be a full and exhaustive explanation of any presented topic. It should not be used to replace the advice of legal counsel. Legal advice must be tailored to the specific circumstances of each case. While every effort has been made to present current information, anyone hearing this information should conduct their own research and seek their own counsel to verify the applicability and current status of the information presented. Laws reflect the values and interests of society that created them at the moment in time that those laws were created. Laws regarding animals are no exception. In ancient civilization, identifying animals as property made sense. Animals were trained to be used as tools to assist in working the land. Other animals were used as tools, trained to assist people in hunting, for transportation, or to carry messages. Animals not used as tools to obtain food became food, or had their byproducts such as milk and eggs consumed as food. Therefore, it was not difficult for our ancestors to think of an animal in the same way that one thought of a table or a chair. Animal laws were likely to be affected by biblical teachings and gave people further rationale for treating animals as property. Genesis specifically granted people dominion over the fish of the sea and over the fowl of the air and every living thing that moveth upon the earth. Yet the Bible also recognized animals were something more and required animals be treated humanely. This likely gave rise to the inconsistent views for how animals are viewed in the law, normally being viewed as property, but required to be treated humanely, recognizing their status as living beings. The Bible instructed people to treat animals well. God commanded that working animals, like people, should be allowed to rest on the Sabbath. Angels in the Bible scolded people when they beat their donkey. Animals struggling from a load were required to have their burden removed. The Bible also prohibited plowing with an ox and a donkey together, presumably not to unduly burden the donkey or to cause pain for the donkey from the relatively harder workload. Furthermore, Jews were required to kill animals they ate in a way that minimized the animal's suffering as part of their rules for keeping kosher. The first American law that prescribed punishment for animal cruelty was created by the Pilgrims in 1641. They adopted a series of laws called the Body of Liberties. Liberty 92 specifically stated, "No man shall exercise any tyranny or cruelty towards any brute creature which are usually kept for man's use." However, it was not until 1821 that the state of Maine created the first animal cruelty law with definitive penalties. The Maine law provided a fine between $2 and $5 and up to 30 days in jail for a person that cruelly beat any horse or cattle. It included no other animals, so maybe the state of Maine had no dogs or cats there at that time. Today, every state in the nation and the District of Columbia have laws preventing cruelty to animals. Surprisingly, the federal government only had animal cruelty laws related to livestock and research facilities until November of 2019. That's when the Preventing Animal Cruelty and Torture, or PACT Act, was enacted. If these laws did not exist, people could destroy their own animals without repercussions because a person can destroy their own possessions without consequences under most circumstances. Since the laws on animal cruelty vary from place to place, actions that may be considered animal cruelty in one place may not be in another. most state animal cruelty laws have exemptions for hunting, fishing, trapping, research, and veterinary care. They also exempt commonly accepted animal husbandry practices such as dehorning, castrating, and branding. A majority of states also exempt traditional veterinary medical practices from animal cruelty statutes. Perhaps more surprising is that only 21 states specifically exempt the killing of insects, vermin, rodents, and pests from their animal cruelty statutes. A possible explanation for other states not specifically exempting the killing of insects may be because most states narrowly define the word animal to exclude insects, vermin, and other pests. Exterminators probably appreciate this. In addition, 14 states have exempted rodeos from animal cruelty laws, and 4 states exempt zoos and circuses from animal cruelty laws. In 1862, the New Hampshire Supreme Court held that beating a horse to train was not to be an unnecessary infliction of pain in violation of animal cruelty laws. Kentucky still exempts people from prosecution under its animal cruelty laws for injuries or death of an animal when training horses, cats, and dogs for sport or show. We would not want to negatively affect horse races in Kentucky, would we? Numerous states also exempt the killing of dogs that are threatening an owner's livestock or property if that dog is caught in the act of harassing, injuring, attacking, or killing the livestock. Sometimes enforcing animal cruelty statutes is difficult. Statutes often use indefinite words such as unreasonable, unjustly, or improperly. Therefore, criminal defendants charged with animal cruelty often attack the laws for being unconstitutionally vague or overbroad. If a law is vague or overbroad, it cannot be enforced. For example, a law cannot be enforced if, despite the law being neutral in content, is used to prohibit ritual animal sacrifice in violation of the First Amendment's prohibition on the freedom to exercise a particular religion. Another law created to prevent depictions of animal cruelty was deemed unconstitutionally vague and overbroad when it could be interpreted to prohibit the freedom of speech on legal activities such as hunting or the humane killing of animals. However, courts stated that undefined or broad terms in animal cruelty statutes such as reasonable, fair, competent, proper, unjust, or proper care and attention have been determined to be not vague or overbroad and constitutionally acceptable. Unfortunately, this opens another can of worms. Because the words are undefined, each case is fact-driven. Thus, the court has to determine what the standard of sufficient care is in a case prior to finding a defendant guilty on animal cruelty. For example, what proper shelter or protection might be required for one breed of dog might not be proper for another. Could you imagine rules on food or cages being the same for a Yorkshire Terrier as for a Mastiff? That's quite a difference in size and weight. Cases of starvation or malnutrition are usually simple for determining whether animal cruelty exists. However, other cases are more complicated. Animal restraint cases are the most difficult because many cities and states have leash or animal containment laws. Obviously, collars which are embedded into an animal's skin have been held to be animal cruelty. A Pennsylvania court held that when a dog was tied to a chair on a porch and it had tangled itself in a way that could not reach its water and where the owner could not be found for at least 7 hours, animal cruelty existed in that case. Now compare that to Ohio, where the Court of Appeals held that animal cruelty did not exist where a dog was tied to a tree and died from overheating because it could not reach the shade. The court ruled that the defendant lacked the requisite mens rea to show that he was acting recklessly because he had tied the dog to that tree numerous times over 18 months without any ill effect. But the same state later held that if an owner uses an electronic collar and fence to contain a dog, there is animal cruelty if the collar burns a dog. Another area where courts have more difficulty inspecting anti-cruelty statutes is determining when the lack of veterinary care becomes animal cruelty. Several states have determined that animal owners have an affirmative duty to provide veterinary care for their animals. But this duty could work an incredible hardship on people who cannot afford requisite veterinary care. So, what does this mean for poor people that own pets? Washington state has specifically legislated that economic distress is an absolute defense to the duty to provide veterinary care to an animal. However, in Texas, the Court of Appeals reluctantly held that economic hardship is not a defense to the duty to provide veterinary care and upheld the conviction of an elderly woman who tried home remedies to cure her animal. Despite this, the Texas Court of Appeals admonished the prosecutor's office, stating, "In my view, anyone visiting this home should have realized Martinez, poor, isolated, and elderly, needed assistance. Perhaps she could have been educated without the rigors of a full courtroom experience, nothing more than a helpful follow-up visit for the benefit of the other healthy dogs. She did what she could, short of calling for the dog's removal. The inability to care for one's animals, financially or otherwise, may result from the sheer number of animals. Animal hoarding has been recognized as a mental disorder. The law fails to recognize this disorder as a defense as it does not fit within the legal definition of insanity. The law has punished animal hoarders criminally, usually citing the failure to provide necessary shelter, food and water, sanitary conditions, or the necessary veterinary care for the animals. In addition to being criminally charged, some states also authorize the seizure of the animals, which has been upheld as a constitutional taking under the Fifth Amendment. But let us return to our original discussion regarding animals being property. The law can only rule over people and property. Since animals are not people, they are deemed to be property. As property, animals cannot own property of their own or bring a suit on their own behalf. Because animals are deemed to be property, animals generally are valued no differently than a chair, table, or door in the eyes of the law. In many cases, this actually makes perfect sense within the law. For example, if someone was going to kill livestock, the law would simply order that the killer give the owner the value that the livestock could have brought him at market if it was in excess of the value of its replacement. Or perhaps someone killed an acclaimed racehorse. In that case, the owner of the racehorse might be able to recover for siring fees, loss of future earnings on races that the horse could have participated in, and any other income that the racehorse reasonably and foreseeably could have earned its owner. However, what if the animal is not a racehorse or livestock? What if the animal has no real market value, as in the case of a pet? Sure, we love our pets, but how can we put a number on their replacement? Traditionally, if an object, or in this case an animal companion, has no market value, then the owner cannot recover any monetary damages associated with its loss. This is a result that probably outrages many of our nation's pet owners. In an agrarian society, cats might have had the purpose of ridding barns of mice or other disease-causing rodents. Dogs might have had the purpose of safety and assistance in hunting. Today, however, the United States is largely an urban society. Dogs, cats, birds, and other animals are not kept for a utilitarian purpose, but for companionship and love. In fact, many pet owners, like myself, see their pets as members of the family. Consequently, owners go through similar stages of grieving when their pet dies. Given these new realities, state courts and legislatures are struggling with determining the proper monetary value to award an owner when companion animals are harmed. There's a modern trend for pet owners asking courts for emotional distress damages or the recovery of pain and suffering of the animals and loss of companionship when their animal is killed. However, historically, the law will not allow for such awards, as property can merely be replaced or repaired. After all, if someone broke a homeowner's window, the homeowner might be upset. But as long as the homeowner was made whole by receiving the money to repair or replace the window, one would not expect the homeowner to have lingering psychological distress over the original window's loss. Therefore, animals in these states can expect that they will not be able to recover any non-economic damages associated with harm or death to their pet. Most courts also will not allow for emotional distress damages for pet owners who had their animal harmed or killed by a negligence of a defendant. This means that if a veterinarian committed malpractice, the veterinarian would be immune from paying emotional distress damages to the pet owner and is only liable for the value of the pet. Even in courts where you can recover money for the negligent infliction of emotional distress, the requirements of recovery under the legal theory of negligent infliction of emotional distress normally bars non-economic damages for the death of an injury of a pet. To recover for the negligent infliction of emotional distress, one must witness the injury or death of someone else emotionally close to the bystander, usually a spouse or other family member. Note, pet is absent from that definition. Then the court might further require that the bystander have received or been threatened with the same harm as the person who was injured or killed. If the injury or death is not personally witnessed, then there is no liability for the negligent infliction of emotional distress. Witnessing a close friend's death has been held not to create liability against the negligent killer. Thus, it's hardly surprising that a pet, which is considered property, would not give rise to a suit for negligent infliction of emotional distress. However, contrary to the rest of the nation, Hawaii has allowed for emotional distress recoveries associated with the negligent destruction of any property, including pets. Cases sometimes come out differently regarding the recovery of emotional distress damages when the killing of a pet is intentional. The general rule for recovery under the theory of intentional infliction of emotional distress requires that somebody show extreme and outrageous conduct by a defendant that is intentional or reckless and causes severe emotional distress. Conduct is not extreme and outrageous if it is merely insulting, threatening, or annoying. Extreme and outrageous conduct must exceed all possible bounds of decency and must be extreme to the point of being atrocious and utterly intolerable based on community standards. The standard of extreme and outrageous is a very high hurdle and not easily overcome. For example, derogatory comments about one's gender or religion may not overcome the standard of extreme and outrageous conduct. Similarly, when a veterinarian performed surgery based on another animal's X-ray, no recovery was permitted under the legal theory of intentional infliction of emotional distress. It was simple negligence or veterinary malpractice, which is no different than if a medical doctor operated on the wrong leg because they received the X-ray of the wrong patient. So, what qualifies as intentional infliction of emotional distress? Well, in one case, a police officer that trespassed on someone's land and intentionally and unlawfully killed a pet dog, that police officer could be held liable for the intentional infliction of emotional distress. Similarly, when police wrongfully kill a wandering pet, it is a violation of the seizure clause of the Fourth Amendment and thus could entitle a person to damages for intentional infliction of emotional distress. Shooting unlicensed dogs and then depositing the dead dogs' bodies on their owner's property has also met the extreme and outrageous threshold. Despite the fact that a majority of states do not permit emotional distress damages associated with the injury or loss to the pet, the law does permit some recoveries. Each court starts from the premise that when a property is damaged, one is only entitled to the fair market value of the object or the cost to repair it, whichever is less. If the cost to repair is greater than the fair market value of the property, then the fair market value is the cap of the recovery. Fair market value includes the depreciation of a property. So, recovery for the loss of a 12-year-old dog is likely to be a lot less than that of a puppy. However, the law recognizes an exception to this rule, the uniqueness theory. I think this legal theory has the best chance of increased monetary recovery for the loss of a pet as the law currently stands. For the uniqueness theory to apply, an item must have nominal or no fair market value. The item must have an intrinsic value, unique to itself. For example, there's only one Jazzy in the world or one Fluffy. Another example might be that of an old watch. The old watch might have no value in of itself, but if it is an heirloom that has been passed within a family for several generations, there's a value to that owner that is greater than most anyone else in the world. The same would hold true for items like family portraits or trophies. Courts that have utilized the uniqueness theory have recognized that companion animals have a similar intrinsic value to the loss of an heirloom or a family portrait. Generally, sentimental value and loss of companionship may not be used in calculating the intrinsic value to the owner. The court must look to the animal's qualities, characteristics, usefulness, services, and pedigrees in setting a value on damages. This may include the animal's potential loss of income to the owner. Michigan, unfortunately, in 2002 specifically stated that this theory only applies to heirlooms, so it cannot be used in Michigan for the loss of a pet. However, in New Jersey, the court utilized this theory to allow for $2,500 in veterinary expenses when a replacement dog would be worth $500 because the dog found the pet itself had no actual market value. As this discussion has shown, people have paradoxical views regarding animals. On one hand, people want to create laws that recognize that animals are living, breathing creatures that have the capacity to feel pain, and animals should be treated in such a way that such harm is avoided. Simultaneously and contrarily, laws reflect that when the animal has a human utility, whether as a food product, a tool for research, or for sport, in hunting, rodeos, or other displays, that animals are much more likely to be construed as objects. However, these paradoxical views are not new. After all, the Bible simultaneously gave man the dual responsibilities to care for the animals, not act cruelly towards them, and at the same time use the animals for all of man's needs. This observation leads to the obvious question: how does one reconcile these apparently opposing views? The answer is that these views are not entirely contradictory. Overall, laws affecting animals have been created for the purpose of giving humans the greatest possible utility of animals. Our laws for research give us permission to use animals, with few restrictions, for any purpose to advance science. In a similar manner, we protect hunters from having their right to hunt, fish, and trap, protecting our interest in using animals for food and clothing. The Endangered Species Act may protect certain animals from being slaughtered out of existence. However, the reason for that is that we have no idea what effect the extinction of an animal would have on people. Furthermore, the purpose of the statute is to restore the animal, presumably, so that we can hunt, kill, trap, or otherwise utilize the animals again in the future for our benefit. Livestock are used for food, and the law only gives them naked protection. In most cases, livestock and poultry are immune from the cruelty statutes. Under federal law, these animals are permitted 28 hours without rest before slaughter. These laws also supposedly assure a humane slaughter, so we can appease our disdain for the abuse of the animals. Animal cruelty laws were created for the purpose of preventing pain to animals. However, while the laws were created with humanistic purpose, they also serve a utilitarian purpose. Psychology has shown that there is a correlation between animal abuse and the abuse of people. Many of the animal cruelty statutes state that a person convicted of animal abuse may not own an animal and is required to go through psychological counseling. The animal cruelty laws, in effect, are an early detection device to catch potential human abusers and get them the psychological care that these individuals require. Therefore, these laws clearly have a utility to humans beyond altruistic purposes. Even pet ownership laws have a utilitarian purpose. As discussed, animals are considered property within the law. Pet ownership often requires licensing and animal containment rules that further enforce an animal's property status. If an animal had unique rights of its own, would it want to be owned as a pet? If animals had greater rights, could veterinarians afford to practice veterinary medicine, given greater risk for malpractice claims. And with greater risk, veterinarians would have to raise the price of their services. If they did that, would humans be able to afford veterinary care for their pet? These are the very same questions that lead courts to prevent owners from the recovery of emotional distress damages because it would open the courts to an uncontrollable flood of litigation. By not permitting animals some sort of status other than being property, we free people to own and love animals without the fear of infringing on an animal's rights. Therefore, while societal views may change, laws regarding animals will likely continue to be created and refined in a way that can best provide utility to people. If you would like more information on this podcast, including the case law or statutes that were used to create this podcast, please feel free to comment below. Also, please comment if you have other legal topics that you would like discussed. And of course, if you enjoyed this podcast, please do not forget to like, share, and subscribe. Thank you.